Welcome back to our top 10 divorce myths with Austin Chessel and Soila Sindio. And we've done the first five, so we're looking at the next five. So if you've missed the first five, just go back to our YouTube videos or on the website and you will find the first five. So the next one, which would be number 6, is do I need evidence for my divorce to be approved for unreasonable behavior?
Okay, when you do the divorce petition, I wouldn't say you need hard evidence, but what you're putting down as reasons for why the other person has been unreasonable towards you needs to be true, and you need to evidence that to the judge. So you'd normally need to list 3 to 4 reasons why during the relationship you felt that the respondent was being unreasonable towards you. And if the judge is satisfied with that, then that should be enough for the divorce to move forward.
Okay. Austin, I've had this question over and over again, whether it's in forums or just reading people's blogs. What is regarded as unreasonable behavior?
So it's a very subjective test, but common examples could be that one person was causing a lot of arguments.
Okay.
You may have been frozen out, isolated from friends or further family.
Yeah.
If one person is really working unsociable hours and not making an effort to make the relationship work, those tend to be common reasons.
Okay.
Also, if someone was violent towards you during the relationship, that's not acceptable.
Mm-hmm.
So those tend to be the common reasons. But every couple is different. So you would just have to say why, in your opinion, you felt that this person was unreasonable towards you.
Okay. All right. Next, we have the question: can the court force me to sell the former matrimonial home?
Potentially, the court can do, but again, every family is different.
Mm-hmm.
It may be that the court says that the house is sold when the child gets to 18, or it may be that the other person who's not living in the property puts a charge on the property so they can realise that amount when the property is sold at a later date.
Okay.
But potentially, even though you've lived in the home for however many years, the court does have the power to order that the property could be sold, because in many cases the house is the major asset. The equity is tied up in the property, so sometimes it needs to be realised.
Okay, so it can be sold or it might not have to be sold.
They may say it's not sold now, but the court would normally put a timeline on the property has to be sold when the children get to a certain age, or within however many years, depending on that situation for the family. But the court does have the power to order for a house sale.
Okay, all right. And then we have number 8, I think it is. If my spouse does not sign the divorce papers, can I still obtain a divorce from the court?
Yeah, I mean, we touched on this earlier with the process server.
Yes.
When the papers go to court, the respondent has normally 2 weeks to complete the acknowledgement of service and return that to court. If it's looking this is unlikely to happen, you can either use someone from the court staff, or I normally use a process server, which is like a detective, to serve the papers on the spouse. They write up an affidavit, and then you can then apply to court that the person has had sight of the divorce papers and they're just being difficult. And then if the court is satisfied with this, then the court can make an order for the divorce to move forward.
Without the other person signing?
Without the other person signing.
Okay, that's interesting. And can you divorce somebody? I'm thinking of one particular case where they had gotten married and she moved back to her country where she was from. He stayed here. They'd never had any children, and they stayed like that for years without having gone through the divorce. And then he decided that actually I do want a divorce, but he didn't know where she was.
If you haven't been communicating, there's a ground of desertion.
Okay.
But you have to have been deserted for 2 years.
2 years.
You need to evidence to court what steps you've made to trace the person.
All right.
And then if the court is satisfied with that, you can then have the divorce proceed on the ground of desertion.
Okay, all right. So the question number 9, or myth number 9, do we have to go to court to sort out the financial settlement?
You don't have to go to court, and a lot of the work I do is non-court based. So I'm a family mediator,
Yes.
so if you agree the children arrangements, financial arrangements, that can be documented and then sent to court. So you physically don't have to go to court if you agree it through mediation.
Okay.
Also, as a solicitor, a lot of the agreements I reach out of court through correspondence. There's also collaborative law where you can have two solicitors who have done that training with the client who can try and talk things through, and if they agree something again, it means you don't have to go to court.
Okay.
But you have to be realistic. Some cases do have to go to court, and if you do, you would just seek for the appropriate court order. But most cases do settle before a final hearing, because obviously every case through the court system is going to incur you more costs.
Okay. And there's this issue that we saw recently when I was referring a client onto you, where her solicitor was kind of telling her that because she was high net worth, they had quite a bit of money, that family mediation was not the way to go when you are high net worth. Is that really the case, or?
I've dealt with mediations where they've had millions of pounds of assets, but what you have to weigh up, if you're coming to mediation, I don't have the power of the court to force someone to provide documents, so you have to have that trust element. If you feel that the other person is not going to provide honestly the financial disclosure of what they're worth, the mediator doesn't have the means to force that person to do that.
Okay.
So it may be in that situation where if the mediation is not working, the trust is broken down, yes, you may have to go to court, but just because the case is high net worth is not a barrier for the case going to mediation.
Okay.
And
go on, sorry.
as a mediator, I work with many solicitors, so the clients have legal advice throughout, so it's really collaborative of working together. So even though the case is being referred to mediation, I still ensure that the clients have legal advice from their solicitors, and if the agreement is reached, then the solicitors can prepare a document for the court.
Okay, all right. And now we have our final one, and which is the children are already suffering because of the divorce. I don't want them to go to court, as this will be too much for them.
So the children wouldn't have to attend the court hearings, but it may be that if the judge feels it's necessary, there's someone appointed called a CAFCAS officer who would meet with the parents and the children. But this tends to be in a neutral setting, so whether it's at school or at their home. So it's not like they're being brought to court under oath. They're spoken to in an informal way to get their wishes and feelings, and that can be then fed back to the judge to help with the decision making. Okay.
And also I think with family mediation, there are specially trained family mediators who do direct consultation with children, don't they?
Yeah, I'd say from my experience it maybe happens 3 to 4 times a year. You need both parents to consent to this. And you would have a separate session with the children, and then you would feed back the information that the children are happy to the parents, and that may then help to make the decision making about where the children will live and how the childcare arrangements will work.
All right. Well done. Thank you so much, Austin. Those are our top 10 divorce myths, or top 10 divorce myths and questions. And we've had Austin telling us all about it. I think we need to do a couple more top 10, Austin, of different ones, because they're actually quite good when you have them broken down as they are. If you're watching this on YouTube, don't forget to visit our other videos on there. We've got quite a few with Austin and other people who are divorce professionals, and some who are actually just sharing their divorce stories. And subscribe to our channel. That's the Divorce Magazine on YouTube, and we have the Divorce Magazine on the site. So thank you so much, Austin, and we'll talk later. Thanks. Bye-bye.
Bye.
Bye.